Be ready. Start. It has been held in that case that a probationer cannot, after the expiry of the probationary period, automatically acquire the status of a permanent member of a service unless, of course, the rules under which he is appointed expressly provide for such a result. Therefore, even though a probationer may have continued to act in the post to which he is on probation for more than the initial period of probation, he cannot become a permanent servant merely because of afflux of time unless the rules of service which govern him specifically lay down that the probationer will be automatically confirmed after the initial period of probation is over. It is contended on behalf of the petitioners before us that the part of R 486 which we have set out above expressly provides for automatic confirmation after the period of probation is over. We are of opinion that there is no force in this contention. It is true that the words used in the sentence set out above are not that promoted officers will be enabled or qualified for promotion at the end of their probationary period, which are the words to be often found in the rules in such eases. Even so, though this part of R 486 says that promoted officers will be confirmed at the end of their probationary period, it is qualified by the words if they have given satisfaction. Clearly, therefore, the rule does not contemplate automatic confirmation after the probationary period of 2 years for a promoted officer can only be confirmed under this rule if he has given satisfaction. If the order of appointment itself states that at the end of the period of probation, in the absence of any order to the contrary, the appointee will acquire a substantive right to the post even without an order of confirmation. In all other cases, in the absence of such an order or in the absence of such a service rule, an express order of confirmation is necessary to give him such a right, where after the period of probation an appointee is allowed to continue in the post without an order of confirmation. The only possible view to take is that by implication the period of probation has been extended, and it is not a correct proposition to state that an appointee should be deemed to be confirmed from the mere fact that he is allowed to continue after the end of the period of probation. The relevant rule stated that the probation in the first instance is for 1 year with the proviso that the total period of probation, including extension, shall not exceed 3 years. In Dharam Singh's case, he was allowed to continue without an order of confirmation, and therefore the only possible view, in the absence of anything to the contrary in the service rules, was that by necessary implication he must be regarded as having been confirmed. The question of deemed confirmation in service jurisprudence, which is dependent upon language of the relevant service rules, has been subject matter of consideration before this court times without number in various decisions, and there are three lines of cases on this point. One line of cases is where in the service rules or the letter of appointment a period of probation is specified and power to extend the same is also conferred upon the authority without prescribing any maximum period of probation, and if the officer is continued beyond the prescribed or extended period, he cannot be deemed to be confirmed. In such cases, there is no bar against termination at any point of time after expiry of the period of probation. Other line of cases is that where while there is a provision in the rules for initial probation and extension thereof, a maximum period for such extension is also provided beyond which it is not permissible to extend probation. The inference in such cases is that officer concerned is deemed to have been confirmed upon expiry of the maximum period of probation in case before its expiry order of termination has not been passed. The last line of cases is where, though under the rules maximum period of probation is prescribed, but the same require a specific act on the part of the employer by issuing an order of confirmation and of passing a test for the purposes of confirmation. In such cases, even if the maximum period of probation has expired and neither any order of confirmation has been passed nor the person concerned has passed the requisite test, he cannot be deemed to have been confirmed merely because the said period has expired. Thank you.